Good afternoon. Thank you for joining us. As Drew mentioned, we're going to be looking at how to review a survey primarily from the perspective of what you need to look at for title insurance. And as we begin, a couple of disclaimers. First of all, I am not a surveyor. I'm a lawyer by training. I spent 41 years in private practice doing a whole bunch of closings. Some of them residential, but primarily commercial transactions of every type you might imagine, from the local drugstore or convenience store all the way up to chemical plants and asphalt terminals and ports and casinos and everything else that typically creates a problem. Also, not an engineer, and I'm not even good at geometry. I tell people I went to law school because they told me there would be no math. I later found out they lied when I got into the real estate and spent a lot of time having to deal with angles and courses and distances and curve data. Had I known I was going to spend my life doing that, I probably would have paid a little closer attention in geometry. So again, we're going to take a look at surveys today from a title examiner's or title insurance perspective. And as we start that, I want to mention a couple things about survey coverage and title insurance. First of all, as most of you probably know, with the exception of the short form loan policy, survey matters is one of the standard exceptions in both in all owners policies and in the long form loan policy. And here in Mississippi, the exception looks like this: encroachments, overlaps, boundary line disputes, and other matters which would be disclosed by an accurate survey or inspection of the premises. Your exception in other states may look a little bit different than that. We issue a lot of short form title policies, and they give survey coverage without having to have a survey, and that's one of the benefits of them, apart from their obvious ease to use and issue. And the critical thing is that they're only issued in proper circumstances, and that is they're covering 1 to 4 family residential properties. They're either in platted subdivisions or here in Mississippi on tracts of land that comprise less than 25 acres. In other parts of the country, you may have different requirements for issuing them, but those are here. And here we also like them to be owner occupied. I'm not sure that's the case in every state. One thing to be very careful with in them is to use extreme caution if you are issuing a short form title policy on new construction, because we and our competitor companies handle a lot of claims where houses are not built on the proper land. When you are granting survey coverage, the survey must be an ALTA survey with the appropriate Table A items, and we'll talk about what that is in just a moment. In some rare instances, let me mention, your underwriter may authorize you to accept something less than an ALTA survey, but you would need to get that permission from the underwriter. And if you're going to grant survey coverage, you must not simply delete or strike through the standard survey exception. I have been asked this question quite a number of times when I've been with the company. So I've got a survey, so now I can give survey coverage, right? Well, yes, but it involves a whole lot more than simply striking through or deleting that standard exception. Instead, you replace that standard exception with what we call a survey read exception. And here I'm going to show you an example of one I have changed all the identifying data on that came. It's a recent one I did for one of our agents. I helped them review the survey and came up with this, but they always begin with something like this: all of those facts and matters revealed by that certain survey of whoever did it, dated whatever dated. And then if the survey has a job number or something, it's also good to indicate the job number right here, including not limited, but not limited to the following. And then you index everything that could possibly be a title issue with that property. And when we go over the checklist in a few minutes, we'll talk about some more of these things in detail. But you can see here, curb cuts, there were, on this survey, there were curb cuts, drain pipes, drain inlets, and various utility boxes lying outside the boundaries of the property owned to the right of way, but obviously they were servicing the property. And then you got some drain and curb cuts extending onto adjoining property to the east. You got overhead power lines, telephone boxes, and you go through all of this stuff, and we'll look at this a little more when we go through the checklist. One of the interesting things about this property is the very last one. There's a sign on the northeast side of the property along with an asphalt drive, walking trail, and curb cuts. The critical thing there is walking trail. And so on this particular transaction, it was near a lake that had a walking trail. And so in addition to this survey exception, we asked the agent to put in a separate exception for the rights of others to use the walking trail. And then somewhere up here, I think, item I, encroachment of the lake owned to the subject property. And so we asked the agent to put in a similar exception for that, rights of others to use the lake. So anyway, that's just an example of what a survey read exception looks like. I know that Roy Perilou, who's our state underwriter here in Mississippi and a senior vice president of the company, is often asked about these or asked to help draft them. So that's just a little idea of what one might look like. One of the things as we go over the checklist you'll see is that you've got to make sure that the survey is the correct type and classification. And let me mention that every state, I suspect, has by statute or rule set forth the requirements and types of surveys. Here in Mississippi, they appear on, I think, Rule 31 of the Rule 21 of the Professional Engineers and Surveyors Board. And it not only delineates the different types, but it tells you the requirements for each type. And I know that every state probably has either statutes or rules like that. It's a very good idea to take a look at those and familiarize yourself with the particular requirements because they may vary from state to state. Our rule defines several survey types. There's a topography survey, a boundary survey, which is what you most often see in the transactions we deal with practicing law. There are other types. There's a lease survey. There's something called a control survey, which is establishing points that will be used for other future surveys, and just a whole variety of them. Every state has its own classifications. In Mississippi, let me go back here. In Mississippi, I'll show you those classifications in a minute. They're A, B, C, and D. And then the ALTA, and ALTA stands for the American Land Title Association. NSPS stands for the National Society of Professional Surveyors. They came together and came up with certain classifications. All surveys should have the state classification and whether or not they are an ALTA compliant survey. So here's a chart where you can see the A, B, C, and D classifications under the Mississippi rule and the requirements or standards for each of those classifications. And to be honest with you, as many surveys as I reviewed, all these numbers mean very little to me. I mean, if you look at them, it becomes patently clear that these standards for the Class A survey are much more stringent than the others, and going all the way down to Class D. But what is really important is what they're used for. So Class A would be for urban business districts, Class B in certain circumstances for urban, C for suburban, and D for rural. So we have a lot of farmland, forest land, and that type thing in Mississippi. So we see a lot of Class D surveys. But if you see a Class D survey in the middle of a town, that's not good, and that's not going to get the job done. Now, most surveyors these days are using GPS to conduct their surveys. And so what I am told by them is if you've got it, for instance, a Class D survey, but you really need a Class C, when I've contacted surveyors in recent years, they say, okay, well, that's no problem. My instruments already have it to the specifications. I'll just certify to Class C. So basically what they're telling me is their instruments are really doing the most stringent standards. They just certify to the least stringent that they think they can, well, that will satisfy the transaction. So anyway, just know that if it's not the correct classification, it may be no big deal to get it reclassified. We talked about that. All right. So the ALTA surveys, you generally need to tell the surveyor in advance you want an ALTA survey. And when you do, he is going to ask you which table A items you want. And there's a whole list of those I did not include. The first 6 of them are over here to the left. And what I would suggest to you, if you're regularly in the business of ordering surveys, or even if you're not, before you do order one, or your client orders one, talk to your underwriter about which table A certifications they may want. These are standards developed, as we talked about, by ALTA and the NSPS. The latest version are the 2021 standards. And it's important to note that if there's a conflict between the ALTA and NSPS standards, the rule provides that the more stringent standard controls. So for instance, here in Mississippi, if we get an ALTA survey of highly urban area, it'll be a Class A survey, also ALTA NSPS compliant with whichever table A certifications we've asked them to do. And there's some unusual things in there. For instance, just to kind of give you an idea, over several years ago, I closed some transactions for property that was right in the glide path of the Jackson International Airport and very close to it. So there were some multi-story buildings on that piece of property, and we had to get the surveyor to certify the vertical height of those buildings to make sure they did not violate the airspace easement, which was, I think, a 50-to-1 glide space ratio. And so there's some very strange things. You kind of need to know what your property is before you order the survey. Which brings up another point. Clients like to order surveys in advance of anything else. But 2 things will happen if they do that. One is it may not be the right survey. So if you can be involved before they order the survey to make sure they order the correct classification, then it saves everybody a lot of trouble. The other thing there is, if we're going to grant survey coverage, we want that survey to be keyed to the Schedule B2 exceptions on the title commitment. So if you can do the title search first, give the commitment to the surveyor, he's not only got any record easements he can locate, but then he can list your Schedule B2 exceptions and note on the survey whether they're applicable or not applicable. And I really didn't mention this in any of the slides, but what you'll usually see the surveyor put three things on one of three things under each of those exceptions. He'll either say on plat, see item G or whatever, and he'll have a big G on the plat where that easement or whatever the exception is located, or he'll say not applicable, or he may say applicable but not plottable. And you'll see that a good bit on things like, your Schedule B2 exceptions will have covenants, and those are applicable but they're not plottable. So you'll see that a good bit as well. And of course, as we mentioned, he needs the Table A. Let me mention that. Right, as you begin to look at surveys, at least in this part of the country, we're starting to see a lot of references to state plane coordinates. And for those of us that are accustomed to traditional surveys, they don't really make a whole lot of sense, but they're an emerging type of survey, and I think we're going to see a whole lot more of these in coming years, particularly as the new datum set is released, which I'll mention in a minute. And they're based on a system established by Department of the Government called the National Geodetic Survey. There are two sets of data currently, 1927 and 1983. I don't think you will ever see anything referencing the 1927, because by the time surveyors, at least in this area of the country, started referencing state plane coordinates, the 27 set of datum was no longer applicable. They have to tell you, if they're using those, the particular zone. And although you'll see the numbers expressed as east or north, south, east, or west, there is something called a YN coordinate that gives you the north-south position, and the XE coordinate, which gives you the east or west position. I don't think I've ever seen them referred to YN or XE. You'll either see north or south or east or west. And they're based on an ellipsoid, which is this shape of the earth over here. And it's a system for locating a particular point on the ellipsoid. Interesting thing about the 27 data, everything was keyed to a particular ranch in Kansas, which I thought was pretty strange. 83 data is not keyed to any particular point. And there is a current data set under development, and it will be based on a global navigation satellite system. And because of the way that appears in the literature, I'm guessing that's something perhaps other than GPS. The benefits of the state plane coordinate system are it's very accurate. It doesn't depend on any variables that may change over time. That once established, you can always go back and locate that particular point. Surveyors have software which converts GPS positions into the state plane coordinate system coordinates. And the difficulty for us as title examiners is we don't really understand those numbers. So there's an example here that I edited so you wouldn't know exactly where it is, but it gives you, kind of shows you what one might look like. And you can see down at the beginning that, first of all, the preamble tells you which zone. It's the east zone, NAD 83, and the epoch is a current version, which version of that data. I suspect that's similar to a revision. There's something called a convergence angle, and I have no idea what that means. Down below, you can see they followed the traditional course and distance description, but then in parentheses, they put the Mississippi State plane coordinate system numbers there. So got the best of both worlds there. And let me mention this as we segue into looking at the actual checklist. I'll share with you my methodology for reviewing surveys. This may not work for you, but in the for what it's worth category, here it is. I start wide. I look at those things that affect the acceptability of the survey. Things like, is it the proper class? Is it ALTA compliant? Does it have the Table A items? Is it signed? Does it have the surveyor seal? Things like that we'll see on the checklist. Once I do that, I then verify the legal description, and we'll talk about ways to proof the legal, but what I'm doing there is basically two things. One, I'm trying to make sure that the typed description I got from the surveyor matches what's on the plat, and there's a significant percentage of the time they do not match. And if you remember nothing from today's presentation, I would tell you that's the most important thing to remember. Closing agents, lawyers, we all tend to want to take that legal description that came from the surveyor, reference it in our deed or mortgage or deed of trust or whatever other document as Exhibit A and just slap it on to the back. But what I learned over the years is that the very sophisticated CAD software that surveyors use, and which is great for developing or creating their plats, does not generate those typed legal descriptions. The surveyor or an assistant or a secretary or somebody is taking the plat and manually typing those legal descriptions. And you know what that means. They are just as prone as a lawyer or a closing agent to make an error in those. So just please keep that in mind. Once I've verified the legal description, well, let me back up. The other part of the verifying the legal description is I want to make sure it's our same property, that it's that is the property we're described in our vesting deed, current vesting deed, or that it's derived in some way from that description. Once I do that, I narrow the focus to matters of concern that might need to be listed on that survey read like we saw a moment ago. And we'll go over some of those on the checklist. So here's the checklist, and some of the things are self-evident. I want to make sure it's signed by the surveyor. Now, let me say, oftentimes when I review the survey, it's the preliminary, and it's not signed by the surveyor, and we're making comments or things that need to be addressed by the surveyor before he signs it. Same thing with number 2 there, the surveyor seal. I want to make sure it shows the north arrow and reflects that north arrow was determined by an acceptable method, and we'll talk about that a little later on. Under our rules, it must show the property address or location. If the property does not have an address, and the location would just be, if it's in a platted subdivision, it would be, lot 36 of the subdivision. If it's not, it would be in down to like a quarter section or something like that. I want to make sure that the survey is current enough to comply with our underwriting standards. So you'd need to look at your particular state and see how recent the survey must be in order to use it for survey coverage. And the next one is one that probably has the most errors on it, and that is that the surveyor's certificate is addressed to the proper parties. You're typically going to want it to be addressed not only to the buyer, but to the closing agent, and it must be addressed to the title insurance company if we are going to rely upon it to grant survey coverage. And more often than not, the initial survey I look at does not have all the necessary parties, or even if it describes security title, for instance, there's a good chance it spelled our name wrong. For instance, guarantee may be spelled Guaranty rather than Guarantee. So anyway, pay close attention to that. Then next up, of course, is it ALTA NSPS with the appropriate Table A items? Is it the proper classification for the property type? Again, if you're looking at a convenience store located within a suburban area, you don't want a Class D survey. And then this is where a lot of them really start becoming deficient. Under our rule, the surveys must index the documents they use to prepare the survey. So they should have gotten the record, the deeds, copies of any easements that were known, any other document that they used in preparing the survey. If you don't see that on the survey, then they either just didn't list it, or they just went out there and did a survey of what they saw on the ground without reference to any of the record title documents. And of course, that's not acceptable to us at all. The next item is not something required by the rule. This is my personal item. I want the survey to reflect that they have called the 811 people, and here in Mississippi, that's the people that you call before you dig, so that they mark any underground power lines, water lines, anything that's known in their system. And I want to make sure that was considered, because there are a lot of instances where there are underground lines that are not readily visible. There are no pedestals or anything which would indicate that that line is running through your property. Several years ago, I represented or was involved in a case where one of the dollar stores in one of our medium-sized cities here bought a piece of property, and they had their dirt contractor out there getting ready for the foundation, and they were digging for pipes and everything, and they dug through a sewer main, big sewer main. It just went directly across the middle of the property. There was nothing on the property that would indicate that sewer main was there. And of course, when the city was contacted, they said, well, that line's been there for at least 100 years. Well, great, but where's your easement? And it later developed there was never a recorded easement. And they, as you might imagine, tried to argue adverse possession, but our law here does not allow you to adversely possess something that's hidden. And that line was clearly hidden. My thought is they probably really didn't even know it was there. Moving along on the checklist, you want to make sure that the survey shows the information for the adjoining properties. And I run into this issue a lot in reviewing surveys. It should show the book and page, parcel number for the adjoining properties, and it should indicate whether there are any encroachments. And, if there are encroachments, we like to see those with some sort of dashed or different colored line. But you'd be surprised how often surveyors don't do that unless you ask them to do that. And then the next one, same situation. Somewhere on that survey, we want a certificate that it's the same as the record property or reflects the differences. And if it's a new description, one being carved out from a larger parcel, we want a certification that it lies within that larger parcel record description. And we've already talked about the type legal that comes from the surveyor. You want to make sure it matches the plat. And then we'll talk about this a little more in a moment, but I also like to independently plat that legal description to make sure there are no errors and it looks like the survey. And most of the time, the surveyors are real good with their plats. So most of the time it is going to look like that survey, but every once in a while you'll see that it doesn't. Um, as I mentioned earlier, we also want to make sure it's keyed to the Schedule B2 commitment exceptions and addresses those exceptions, shows any encroachments onto or from the adjacent property, or any encroachments onto recorded easements. This is something you see a whole lot of. You know, the parking lot, maybe the pad for the central air conditioning unit, sometimes even the roof overhang is over into the recorded easement area. Uh, if there are setback limits, we want the survey to show that and whether there are any violations. In other words, anything that's built over the setback limits. And then, of course, here in Mississippi, we want it to state whether there are any cemeteries or burial grounds. That's required by our rule. Um, we don't want to insure those create insurance issues if you find some of those. They've got to be accepted from the title policy. And what you would want to do is contact your underwriter to see the exact wording they would like to have for that particular exception. All right, to kind of finish up the checklist, are there any gaps in recorded parcels? If your survey has multiple parcels, we need to know if there are any gaps in those. If there are, you probably want to specifically accept those, and you certainly do not want to give a contiguity endorsement. And then, is there access to a public road? I've got a separate slide where we talk about that in detail in a moment. And are there other matters that may be needed for particular endorsements? For instance, is zoning information shown? In anything but rural land, you almost always want it to show the appropriate zoning. And then finally, are there power poles, guy wires, utility boxes, lines, or any items owned by utilities that might need to be listed on the survey read? And again, this list is not necessarily exhaustive. This is just my list. Your particular transaction may require other considerations, or your particular state may have other things that should be considered. Thought I would mention this, just if you're reviewing surveys, you just kind of know this. It doesn't often affect too much, but on a rare instance, it will. And that is, how was north determined? And so first of all, you got to know what north is. There is something called true north, and I'm going to give you the plain language definitions of these. True north is the point on the globe at the North Pole where the rotational axis of the Earth intersects with the surface. So, as you might imagine, it's an imaginary point, but it is the northernmost point on maps. Grid north, which you won't see too much involved with surveys, but can come into play because it's the grid lines leading to true north. And the problem is maps are flat and the Earth is not. So it creates a slight deviation, only about 2 degrees or so. Note that magnetic north should never be used on a survey. And the reason for that is magnetic north has something called declination, and that's the variance between true north and magnetic north. Here in Mississippi, and the closer you get to the equator, the less declination matters. I think it's about 2 degrees here in Mississippi, but if you're in Alaska, it's about 35 degrees. So it can mean a huge difference up there. But here in Mississippi, at least, there is another form of north that's allowed for surveying purposes, and it is called record north. And I do not like it, but I've occasionally had to deal with it on surveys. And our rule allows a surveyor, for instance, if they're surveying a lot in a subdivision, they may look at the subdivision plat and accept the line that it indicates as north, or north as indicated by that survey, as north for the survey they're doing at that particular moment. It can be not only subdivision plats, but city and governmental surveys that have been filed for certain purposes and other things. And here in Mississippi, the survey must show the method for determining north. So that's just one thing to keep in mind. Proofing legal descriptions. As I start this, let me mention I have lawyer friends who like to proof legal descriptions by giving the new description or the description they've typed along with the record title description to a couple of paralegals, or maybe a legal secretary and a paralegal, or the receptionist and the paralegal, and get them to proof those legal descriptions. And I do not recommend doing that. And the reason is this: sometimes those descriptions get very lengthy, and it's very, very easy for your mind to wonder if you're not truly appreciative of the importance of making sure that description is correct. So, for instance, in my last law firm I was in, I always got my legal assistant, who was also our office manager, to read, and I would be the one following along as she read, because if my mind wandered, I would know that, and I would ask her to go back. Let me just say, she did not like that. She did not like the reading, but really, I thought that was the only safe way to do it. So yes, you must proof the legal description. Some common errors you'll see are wrong numbers, omitted punctuation, omitted or duplicated calls is very common, particularly on those typed descriptions you get from the surveyor. And so how do you proof it? So if you're proofing your description that came from the surveyor with the plat, then you just simply follow along the plat. And that will tell you whether the surveyor made any descriptions in coming up with that narrative you're going to attach to your deed or mortgage as Exhibit A. That's a really good thing to do, and it gives you a lot of information. Tells you whether you're good and consistent with the plat. The other thing to do, which I actually recommend both of these, is once you compare it to the plat, then take your own software. And there's some very inexpensive software out there to plat it with. And one of them is called Deed Plotter by Greenbrier Graphics. One's called Meets and Bounds by a company named Sandy Knoll Software. So, and I think those Greenbrier is a little more expensive. I think you can get Meets and Bounds for less than $100. It's very easy to use. Greenbrier, at least last time I used it, required you to convert the calls into compliant strings for their software, which was a little bit of an issue. Meets and Bounds, you just got a blank. How many minutes? How many degrees? How many seconds? What direction? You just fill all that in for each call, and it does an amazing job. All right, let me mention this. A lot of people are trying to use AI to plat descriptions, and if you take that legal description and you dump it into ChatGPT or Claude or any of the other popular AIs, it will plat the legal description for you. But I do not recommend you do that. And here's the reason. If you're going to do that and you're going to get a product or a result that's reliable, you must give the AI appropriate instructions. And most of us, me included, don't have the skills to develop these instructions. Here in Mississippi, we have an agent who, in addition to all the things he does as a lawyer, is an AI architect for a big AI company out of California. And he uses one of the major AIs to plat legals, but he has developed a sophisticated set of instructions that's probably 2 typed pages long. The product it will generate is phenomenal. but I don't have the skill set to create those instructions. I'm working on a set of instructions. Maybe I can learn that skill set, but right now I don't have it. So I would not use Claude, ChatGPT, or any similar AIs to plat your legals. One thing to remember, if you use them to plat your legals, AIs are developed to please you. So they will correct any errors in the legal description without telling you they've done that, which can create a whole lot of problems. Instead, if you want to use AI, there are options. Several of the companies now have AI platting programs you can purchase. I've not used any of them. Now, there's a typo there. I apologize for that. It should say AI platting programs. But go look at those, because they should have an appropriate set of instructions with them. The only thing I would tell you, not having used any of them, is if you buy them, test them against other sources for a time or two before you start really relying on them. Okay. I'm going to mention this. We talked about roadways. When you look at a survey to determine whether there is access, the fact that the survey shows the property is adjacent to a road does not guarantee access. Let me repeat that. The fact that the survey shows the property is adjacent to a road does not guarantee access. Access is one of those things we insure and can result in a tremendous loss if the property in fact does not have access. So here's some of the situations. Here's an obvious one. If you're located next to an interstate highway and that's the only property, the only highway, contiguous with the property, you don't have access. A little trickier deal, boulevards. A lot of boulevards, you'll drive down them, you'll see entrances and exits to various business, and you'll think, oh, there's access here. Well, if it's a boulevard, it may have limited access. You may not be able to get access. Some U.S. highways and some state highways require permitted access, and there can be conditions where you might not be able to get that. One of those, probably the most common one, is if your property can only access that road in close proximity to an intersection, you may not have access. Here in Mississippi, there are also issues about whether the road is public. The survey may show the, Oak Road, and there can be a real issue about whether it's public. If there's an easement for the road, it's generally pretty reliably public. And let me just say, some roads you'll know are public. But here we have a lot of them. The road is there. You don't know whether it's public. The county is supposed to maintain a list of public roads. They may not maintain that list. If they do maintain the list, you've got to see whether the road is on the list. If the road is on the list, then you've also got to determine whether that portion of the road contiguous with your property is on the list, is on the county list. Because sometimes those county roads, they are public, but then there's a point at which they become non-public. I was going to show you a couple of things here, and I'll mention these just briefly so we can get to the questions. This is the reason you plat. See these lines here? This was a lot of property owned by a state entity here where they do long-term residential leases on them. This property had been used in the this description had been first used in the 1960s, used through a succession of assignments of that lease in the intervening 60 years. While I was on vacation one year, one of my partners closed on this lot. I came back and my legal assistant said, he had closed on this lot and we're ready to issue the policy. Could you sign the policy? I picked it up. I looked at the description in the policy and I said, this description doesn't close. And she said, there's no way you can know this. And I said, well, I've seen enough of these. I can tell you something's wrong here. So when we platted the description out, when I ran it through the software, this is what it looked like. And this is a very common area. One of the calls that should have been, you know, north 90 degrees east was north 90 degrees west. And there was a wrong direction in that call. Here's another one. This is what happened when I platted the description. You can see it doesn't close. It probably did close legally because the final call was to the call beginning or point of beginning, but that would have created some problems. When I overlaid it with the survey, you can see they don't match. And the reason they didn't match was some errors in calls right in here. This was a nightmare to deal with. This I show you, this didn't involve a survey, but I wanted to show it to you because of the importance of always platting your descriptions. The legal description was track 1 and track 2 lessen except this little red track right here. If you just looked at the narrative legal description, it all made sense. You didn't see any problem. But when you plat it, there's one obvious problem. The road is right here. And what you can't see from this map, but you could see from the GIS maps, the driveway ran right. Uh-oh, let me go back. Ran down here and over to the road right there. And right here on the red track was a house that obviously needed that driveway to get to the public road. So had I not platted this, I would not have put an exception for any easements or claims to easements over that driveway. But since I did plat it, I could see the issue and do that. Real quickly, another one, 3 tracks. These are the 3 tracks right here between the 2 tracks. When you looked at the GIS map, was a public road. When you looked at satellite imagery, it was very clear that this owner was not using or claiming this property. In fact, you could see where the old road bed ran through that property and had at some point been diverted over here. So we just simply didn't insure that little track. Since we're running out of time, I won't go through most of these with you. I will show you this one just for humor. This was a lawsuit I handled, a claim for a title insurance company when I was in private practice. There were some errors, title issues with this tract. They made a claim on their loan policy, but some issue came up that caused me to order a survey. I got it, and look at what you see. Remnants of brick house destroyed by fire. Well, that affected our lawsuit tremendously. So anyway, I won't go through the rest of these because I think we need to leave some time for questions. Drew?
Sure thing. Please submit your questions and then we will start getting them answered.
I tell you what, while we're waiting for any, I'll go back to.
There's a comment here. Jeremy, I'll touch base after the presentation. We'll get you squared away. Okay. Well, I guess, Mike, in the meantime, we don't have any questions just yet. So if you wanted to go through any of those slides, if there are any.
Yeah, all right, let me see. Am I sharing the screen now?
No, I see the editor view.
Can you see the screen?
Correct. I can see the screen. You're not in presenter mode.
Okay, how do I do that?
So the bottom right-hand corner where you have the slider, plus and minus.
Oh, yeah, got you.
That little icon there.
All right, did that get it?
Yep.
Okay. So this is a a lawsuit that we handled went all the way up to appeal when I was in private practice. This was a 1960s survey that was on the of record, and notice right there, there's the north arrow. So north is actually this direction over here, and that matters when you see the current survey of this. Right over here, right about where the north arrow is, two very expensive homes built. And as you might imagine, they accessed this roadway right here. And the claim was by the owners of, I think it was these two lots, that we were trespassing, that our insurers were trespassing. And by the way, these were not security titles insureds. This was another company, was trespassing on their property to get to the public road. And they were very belligerent about it. They had surveys when they built the house, both houses, showing it was not. So we got a current survey, and this is it right here. Now north is now up, but you can see that this little block right here is the area that dealt with our properties, and you can see the property line from that old survey is actually right in the middle of the pavement. So we weren't encroaching on their property. The surveyor who did all these surveyings for me over the years was very good, and he was amazed that 1960 survey, he was actually able to go out and locate 3 of the 4 corner pins, and he said it was amazingly accurate for that time frame. The only thing that had changed was the route of the road. At some point in the 1970s, they'd come in and this had become a state aid road. The state had given them a bunch of money to improve the road. And despite all this, the plaintiffs didn't give up. We went to a full trial and then to a full appeal. And so you can see both these in the Mississippi Digest. Anyway, and I think, let's see. Another reason you want to get surveys right here. This was a real estate agent, bought a piece of expensive piece of property out of foreclosure. No survey on it. You see it was 4.33 acres. He went to sell it. The buyer required a survey, got this survey. You can see that the full porch, a corner of the house, was actually built over onto adjoining property. This was a closing I was handling. And so the company that insured his purchase ultimately went in and bought a tract of land over here and was able to get him some yard space, and he was able to sell it. But lots of crazy things happen on surveys. And I think that's about it, Drew, unless you've got some questions.
Yeah, we had a couple come in. I didn't want to cut you off. So the first question is, what about fixing things in descriptions, such as road names that change or bad survey language, such as fence along the same instead of stating the road name again?
Okay, well, so like road names that have changed over the years, that's a great question. And it can create a lot of confusion on surveys. So what I prefer to do is cite the current, change it to the current name, or if you're using an old description, leave the old name in there and then in parentheses say, Baker Lane, parentheses, now known as McKay Drive or whatever, and just make the notation by parenthetical reference. In terms of correcting anything else in a survey, talk to your underwriter about that. Here in Mississippi, it would depend on whether it was critical to the legal description or not. Generally, if it's non-critical, in other words, if the description would be valid without or with that error, you can correct it. If the description would not be valid with that error, then some curative work is probably required.
Great. Next question is, if a driveway / asphalt extends beyond the property line in front of the property, should that be included in the survey read exception, or does it generally depend on the municipality?
Well, that's another good question. So as long as the driveway goes on to the easement, I think you include that. I think you include that in your survey. You just say asphalt driveway extends across property line into road right of way prior to intersecting road or something like that. If it crosses somebody else's property before getting to the road right of way, yeah, that's a problem, and would probably need to be a separate exception in addition to the survey read.